Good evening to you and welcome to continuation of our company law class. Last time we started with the introduction of company law. We proceeded to discuss the sources, and we were supposed to have looked at some other uh, general theoretical and policy issues as part of the introduction. We couldn't finish, so we are going to continue from there. And hopefully, when we finish in good time, we will move straight to our next topic. So, having understood the sources from which we derive the legal norms which constitute company law from, we would like to ask ourselves what should be the proper function or the proper role of company law in an economy. And this question is very important because, mindful of what role company law is supposed to play in an economy, will be in a better position to interrogate the adequacy, the usefulness of the law as we have it, as we discuss the various topics, in finding out whether the law as we have it actually fulfill what we have come to appreciated or understood as the proper role or the proper function of company law in economy. As I said, the difference between us and other people who learn company law as non-law students is that we are going to become professional users of the law. And for that matter, we need to have a matured appreciation of it. So on that note, I would like to bring to your attention that scholars have been divided regarding what should be the proper function and the role of company law in an economy. And if you look at the literature, uh, three dominant approaches are identifiable. These are the facilitative, or also known as the deregulatory approach, regulatory, also known as the prescriptive approach, and if you like, the middle way approach. And I must say that these observations were articulated by Eisenberg in the work he did, The Structure of Corporation Law, uh, many years ago, published in the Columbia Law Review. Out of consolidating your general appreciation of the law, it will not be out of place if you decided to just download the article and run your eyes through it. And building upon that uh, discussion, I also did a work in respect of the Companies Code of Ghana at the time. And this work is a bit outdated, 2007, but the importance of that paper I did in 2007, Reforming Companies Code of Ghana, which way to go, which was published in the Commonwealth Law Bulletin, was that in 2007, there were a number of uh, challenges as far as our company law was concerned. And in fact, there has been call for debates. Call for reforms. So I waded into that and decided to map out some of the challenging areas which would need to be reformed. And thankfully, 2019, we got the new Companies Act passed. So there's a work I have done, I will share with you if you're interested to read, which try to find out whether the new legislation, Companies Act 2019 Act 992, addresses the issues which we identify, the problem we identify with the repealed Act 179, that is the Companies Code at 179 of 1963. So let's say a few things about each of these approaches. So the facilitative or the deregulative approach, what does it tell us? Well, advocates tells us that uh, the role of company law should be primarily that of enabling those engaged in commerce to order their affairs in whatever way that suits their best purpose, with minimal interference from the state. In other words, company law should be enabler. It should give autonomy, it should give freedom to businesses or those who are using the company as a vehicle to run their businesses to use it and deploy it as they deem fit for their business purposes. And they shouldn't be subjected to too many restrictions by the state as a regulator. So this way of looking at the role of company law is premised upon a philosophy or a thinking which is heavily characterized by a strong belief in the principle of freedom of contract and in the power of market forces. As you remember from law of contract, the laissez-faire doctrine and all that, that you have to allow parties, so long as they have the requisite competence or the capacity, to make their own choices as will serve or suit their interests. So it is the argument canvassed by those who support the facilitative approach or deregulative approach that legislation on corporate matters should be as liberal as possible. In other words, you should loosen up things rather than tighten things by way of regulation so that the company can have the freedom to decide on many matters that relate to governance and running of the company. And on this note, I would like to flag for your attention so that when we are discussing some of the substantive thematic areas in this model, you will ask yourself whether you agree with those who maintain that the company law should be largely facilitative or the deregulated. For example, when it comes to uh, governance, meetings, decision makings, how the company decides things, must there be a rigid formula as to how the company get these things done, or the company should be given the freedom to actually decide how it wants it to be done. Again, when it comes to even matters like who qualify to be a director, should the company be given the room to prescribe the criteria, or the lawmaker should do that through the company legislation? So the chief presupposition or the chief assumption of the deregulated approach, also known as the facilitative approach, is that most of the rules in the company's legislation, in our case, the Companies Act, should be default rules so that they become applicable where the company concerned fails to provide for them in their regulation. When I say default rules, you're all living in the computer age, so it shouldn't be difficult for me to help you to understand default. Just as you get your phones or your laptops or other gadgets. We have what do you call the factory settings, right? If you like, and you can modify them as you want. So default rules here also means that yes, those who support the facilitative or the regulator approach of company law says that if you are going to have a company's legislation like our Companies Act, for example, the rules should be default in the sense that they are applicable only where the company concerned has not designed its own rules or has not prescribed how things should be done. But where the company concerned has prescribed how it wants certain things to be done, then that is what should prevail and not the rules. So that is the point they are trying to make by saying that as far as they are concerned, that is the deregulatory approach is concerned, the bulk or majority of the rules in the Companies Act should be largely default, being permissive so that the company is not bound by it necessarily, and they can tweak it or modify it as they want. So at this stage, I would like us to do a short exercise. You have your Companies Act 2019 Act 992, and I told you the last class that you should have it. I would like you to identify at least 5 examples of this approach in the Companies Act. In other words, look at your Companies Act at 992 and find out which provision, in your view, is framed or couched in such a way that is not making things mandatory for the company, and that the company is giving the room to decide how it wants things to be done. So look at your Companies Act and try and give me some of these examples. If you are ready, put up your hand. So let me give you the guide again. I want you to look at your Companies Act, okay, Act 992, and give me at least 5 examples of provisions in the Companies Act which have been formulated or framed in such a way that it is not binding or mandatory for the company to follow that particular provision, and the company may do some other things. Yes, put up your hand if you are ready so that I will release your mic for you. Anybody? Yes, Phyllis. Yes, Phyllis.
Yeah, so it's like this as gives the company option to choose do its own constitution, company's constitution, or use the default one.
Discussion.
the company constitution.
Yeah, section.
The section that I was trying to figure out, it's like one of my readings. I came across something like the company can go with mention something its own constitution or the default one.
Section 20, section 23. Read
Yeah,
section
okay, sure.
23 now. Read it. Read it for us. Section 23, 1.
Okay,
Read it for us.
okay. 23 one. All right. Option to have a registered constitution. 23 1.
Yes.
A company has an option to have a registered constitution.
Okay.
That's the 23 1.
Okay. So that one is even more direct. The provision itself is saying that it has an option, so there's no debate about it. Okay. Can we get other examples? Yes, class. Other examples of provisions which suggest that the company is not mandated to follow a particular path prescribed in the uh, provision. Yes. Yes, go ahead. FAO. Oh, sorry. FAO, go ahead.
Section 6.
Section 6, read it for us.
One or more persons may form an incorporated company under this act.
Okay. Uh, Now, one or more may form. So in terms of the minimum number, it's evident from that provision that you cannot have zero member company, and the company must always have a member. So that one, the company, like if you want to use the incorporated company, you are bound that it must have at least one member. So that one, you don't have a choice. Can we try another example? When we are having a class like this and we ask questions, make effort that you put yourself into it. It's all part of the learning. Can we try another example? Okay, if your hand is up again, okay, you want to try, okay, good. Sure, you can mute. Yep, okay. Okay, I'm going to give you assignments. So take this as assignment, all of you. You just identify the provisions which, in your view, okay, we have somebody who wants to help. Okay, Chris. Yes, Chris. Chris, you can release your mic.
Okay. So, hello, my lord.
Yes.
Section 13(2) talks about registration, electronic registration, the option for electronic registration.
Okay.
Yeah.
Section 13(2). Can you read it for us? The
Okay.
particular provision.
Okay. Um, The application shall include the name of the company as required by Section 21. B, an indication of the type of sponsorship. I think it's actually in E, 2E, 13, 2E, the electronic mail address and website of the company. Then, yeah, yeah, I think D is the address of the proposed registered office and principal place of business, the telephone
Okay,
number, private
let me
mail,
give
or
you
digital address.
good. Thank you, Chris. Let me
Yeah,
give you a
yeah.
certain clue or a trick which you can use to spot the examples.
Okay,
Now, if you look
okay,
at the modal verb, like if you see the shall, in the interpretation
okay,
act, shall always means imperative or mandatory.
okay,
And then if
okay,
it is may is permissive. So
okay,
when may is permissive, it means that you have some kind of like a discretion or some kind of like a choice or option, isn't it? So
okay,
therefore, the provisions where you see that they use the modal verb may, that suggests that it's permissive, it's not mandatory to a large extent.
okay,
But
okay.
this one, you say if you look at the 13.1,
Yeah,
at the 13.2, they have like the shall. And then the
okay,
shall means, I mean, generally speaking, within the context of the Interpretation Act, shall suggests like it's mandatory.
okay, okay. But okay, my lord, I think in 13.5,
13.5.
yeah,
Okay, read it
the
for
application for incorporation may be effected by A, the delivery of the completed application form as required by subsection 2.
good.
B, the delivery of the completed application form as required by subsection 2, accompanied with a proposed constitution.
Right. So good. So
Yeah.
that is a perfect example. You notice that over there is permissive. So it does not come out as being mandatory for the company to use the particular prescribed method, but it has options. Good. Thank you.
Okay.
So let's take FAO. Your hand is up.
Yes, sir.
Great.
Section 12.
Section 12.
Subject to this act, a person of the age of 18 years and above may apply for the incorporation of a company under this act.
Okay. Okay, that is fine. That is fine. But what I'm looking for example, and I can also understand because you haven't started reading the law extensively, so that is why the examples are not readily forthcoming. So after this class, you have been directed to start reading from section 1 of Act 992, and as you read, you pick the examples. Good. I think there's one hand up before we move on. Was there something in the... okay, somebody has provided that Aliyu, Section 19 provides that where the registered constitution set a restriction on business, that restriction does not void as contracts or transfer mere because they go beyond the restriction. Okay. Let me see, is there another hand up? Okay, I think Ade, yes, Ade, let's hear you.
Mm. Good evening,
Good
my
evening.
lord.
Mm.
Please, I was looking at section 37,
Section 37.
power to close register.
Okay. Section 37. Oh, no,
Yes.
read it for us, the relevant
A
one.
company may Yeah, a company may close the register of members or that of the register relating to a class of members for any time or times of not more than a total period of 30 days in each year on given reasonable notice by A, advertisement in a daily newspaper of national circulation in which the registered office of the company is situated, and B, electronic means.
Very well. All right. Yeah, thank you. Yeah, so
Yeah, thank you.
that is also a good example. Okay. I think, Phyllis, I think your hand is the previous one you raised. Okay, good. So let's move on. Then we also have the regulatory or the prescriptive approach. So the regulatory approach espouses the view that there should be more elaborate regulation of how affairs of the companies should be run, so as to forestall the possible abuse of the privileges incidental to incorporation. So this is the reverse of the facilitative approach. Facilitative approach is asking for deregulation. In other words, reducing drastically regulation and giving more freedom to companies to run their affairs as they deem fit. The regulatory or the prescriptive approach is rather saying that there should be more regulation. And the reason for asking for more regulation by the prescriptive or the regulatory approach is that the potential for abuse inherent in the concept of limited liability, and also the massive economic power wielded by largest corporations. So therefore, if you don't impose strong regulatory measures by the legislature, things can actually go out of hand. You can appreciate the argument of the regulatory or the prescriptive approach or school when you cast your minds back to the history of company law, especially history of English company law, where there were major abuses or scandals which necessitated the passage of the first major legislation. There's a phenomenon we call like the South Sea bubble, but just before that, we didn't have the kind of company legislation like what we have at 992 or the repeal at 179 or its equivalents in, let's say, England and Wales or other jurisdictions. Going back to English law, for example, to use the company or incorporated entity as a vehicle for running a business, you had to get Parliament to pass a dedicated legislation, just as we used to have maybe a legislation on maybe the Electricity Corporation of Ghana Act or the PNT Act. You must have like a dedicated legislation which actually set up the particular corporation or company before you could use that. Or you needed what we call a royal charter at the time. You needed a royal charter. So some businesses obtained this royal charter and so on, and they were able to lure other members of the public to invest in them. And they created a certain exaggerated hope of massive profit But in no time, the company collapsed, and that necessitated a public inquiry being instituted into why there was such a major collapse of the company. And because of that, there has been a call for strict regulation of companies. And we will be talking about the privileges which are associated with incorporated company. Like, for example, the principle of separate legal personality, the fact that the business is separate from the human beings who actually own it. Now, unlike sole proprietorship, as you will notice later on, there's no distinction between the person and his business. If the business incurs debts, they are treated as a debt of the person. Creditors can go after him, including even his personal belongings and so on. But if it is a company, the company is shielded. The company is treated as an entity in its own right, so that if the company is indebted, you cannot go after the assets or money of the shareholders, as it were. All that the shareholders will lose is the money that they put in the company by way of the shares that they acquired. So that is the idea or the concept of limited liability. So the regulatory or the prescriptive school hold the view that because of the danger of abusing these privileges, there should be more restrictions, more regulations to direct the company how matters are to be done, rather than giving latitude or freedom to the company to make its own choices. And those who subscribe to the regulatory approach, they also hold the belief that rules of prescriptive nature can be used to make the company a powerful instrument of social engineering. In other words, you can use rules to direct the companies or the corporate world towards a certain direction in order to achieve certain outcomes. So that is the idea of saying that, yes, you can use the rules to make the company a powerful instrument of social engineering. And it can also supplement the law in such other areas as labor, environmental law. So you can, in a way, for example, in Ghana, we are battling with the galamsey or illegal mining, for example. They also support regulatory approach, or for example, say that we can use more regulations to try and get the company to do things which the society or communities consider as noble and worthwhile. And so therefore, we notice that the regulatory school of thought or the regulatory approach favors the company being given very little or no matters or subjects over which it can exercise its own initiative, so that everything is largely prescribed in the law. This is how it should be done. That is how it should be done. This is how it should be done. Then you just have to go through that. Then the company does not really have any discretion or any choices, as it were. So just as we did for the facilitative or the deregulatory approach, I would like to invite you to look at the law, Act 992, and bring out at least 5 examples which suggest that our Companies Act in some respect reflect this regulatory approach. And usually, the regulatory approach, as I told you earlier on, is indicated by, where it's mandatory. And then when it comes like the modal, verb, shall, within the Interpretation Act, it's always mandatory. It's not permissive. So if you can look at it and give examples of those situations in which the law has not given any freedom to the company to decide how matters shall be. Any example? Yes, Ade and then Phyllis.
My lord, I think section 13, 1 and 2.
Okay.
From 13.1, it says that an application for incorporation shall be made in the prescribed form and delivered to the registrar. 13.2, the application shall include the name of the company as required by section 21, indication of the type of proposed company, the nature of the proposed business in the case of a company
Yes,
registered with an
Mr.
office,
Ade, that
address
is
of the
fine,
proposed
but
registered office.
the challenge we have with that example is that now those provisions are the formation stage. The company is yet to come into being, isn't it? So we are rather looking at where like the company is actually incorporated and whether the company has any choices or everything is prescribed. Yes. Yes, Justice. Kutua Champo, yeah.
Thank you, my lord, for the opportunity. Section 126, subsection 1.
Can you read it for us?
Is that a company shall, at least once in every year, deliver to the registrar for registration an annual return, including particulars of every member of the company and every beneficial owner of that company, and in the form and relating to the matters prescribed in the 5th schedule.
Okay, right, good. Good, that's it. FAO.
Yes, sir. 157. Except as provided in subsection 4, a company shall A. in each year hold a general meeting as the annual general meeting of the company in addition to any other meetings in that year, and B. specify the meeting as the annual general meeting in the notice calling the meeting.
Okay, right, thank you. Elvis.
Yes, my lord, please, section 144, subsection 1
Okay,
says that a company shall act through the members of the company in general meeting or the board of directors or through officers or agents appointed by or under authority derived from the members in general meeting or the board of directors.
okay. The ladies, let me hear your voices too. During cancer, your hand is up. Okay.
My lord, section 28, subscription to constitution. The constitution of a company shall be signed by one or more subscribers in the presence of a witness who shall attest to the signing.
Okay. No, but as I indicated when Mr. Ade spoke, that those, I mean, is an example who suggests mandatory, but then the company has not yet come into being. It's still at the information stage, isn't it?
Information stage. Oh,
Yes.
sir. Yeah, thank you, sir. Thank you, doctor.
Yeah, Vera.
Yes, my lord. Okay, section 139, subsection 1. It says that a person shall not be appointed as an auditor of a company unless that person, and the B says, is duly qualified in accordance with section 138.
Right. Right. Thank you.
You're welcome.
Thank you. So all of you also will read the law and be looking out for those examples. Then we have the middle way approach. And those who advocate for this approach propose that company law must act both as a facilitator and a regulator in the economy. In other words, the company law should not be too regulatory, too prescriptive. It should also not be too deregulatory or too facilitative so that anything goes. That you should have the best of both worlds. So be in the middle. There should be some aspect of prescription when the company is directed what to do, and then there should be some aspect where the company is given the freedom to make choices. Yeah, so let's keep that in mind. We will now continue with the historical evolution of company law in Ghana. And as I indicated earlier on, the history of company law in Ghana must begin with origins of company law under English law, or what pertain in the UK, as the case may be. And the history of company law in UK, before we will talk about what we have in Ghana, for obvious reason, that we received our law through the Supreme Court Ordinance of 1876. And for that matter, whatever we talk of as company law, we have to put it in the proper historical context. So, as far as the history of English company law is concerned, probably we could talk about the earliest times until the South Sea bubble, and then we talk about when the Bubble Act was passed, following the South Sea scandal, up to the first Companies Act of 1844. And of course, from 1844 up to the time the UK enters the common market, and from that time up to date. But we are interested in the early times up to when we had our first companies code, 1963, at 179 after independence. So the earliest form of business organization, obviously, was the sole proprietor, and in the Middle Ages, principal trades were regulated by guilds of merchants, which roughly resembled our modern trade protection association, and they had ceremonial and social activities of organizations such as the Freemasons. So the Freemasons, for example, apart from being a very close society, has a history which has to do also with business as well. So guilds actually developed like to protect the various interests which they had, so that those who were producing something like the Texas and the rest, they will come together to form association to protect their interests. But you can even expand it, the history further. If you wanted to look at the early Greeks and then the Roman society, the kind of business, organization which existed before the modern day, incorporated company and the incorporated private partnership. One could, for example, talk of what we call the societas, and then this societas, it was an arrangement in which taxes, if you like, quote unquote, were entrusted in the company known as the societas, and the members of the organization we call the societas, they had what in modern day we call shares. Okay, that was the arrangement. So in Italy, most of the city-states during the medieval and the Renaissance period made use of also what we call the commenda. And then the commenda was equivalent to what in Arabic or early Islamic tradition they call the kirad. And also the Jewish also have something they call the iska. I am mentioning this just to help you appreciate just one point. You don't need to worry yourself about all those historical complexities, but just to let you know that for as long as we have had a human society, we have had businesses running, and there have been various attempts of organizing businesses before we came to have the more refined model, what we call the incorporated company or corporation, which we'll be discussing in this particular course. So that is the point about all this. So nothing for you to really worry about. So they also had, they have the commenda. By the commenda, the investors will entrust their capital or merchandise to an agent manager to trade with and return the principal plus agreed share of profit. Then the remaining profit went to the agent, but he or she bore no liability for partial or total loss. If there was a loss, you could not hold the agent responsible. But if there was a gain, he would take a share of the profit. So that was a business arrangement which was known as the commenda, which was quite prominent in the Italian city-states. So we could say that commenda combined elements of loan arrangements with partnership, but you could not treat it strictly as only loan arrangement, or you could not treat it strictly as partnership as understood in modern sense. So we could say that commenda as a business arrangement meant spreading risk and allowing investors with spare cash to put them into business without running it. So you have money that you don't need, good. You give it to the agent, as it were. He will trade with it, and then when profit is made, the profit will be shared with you according to the agreed formula. But if there was a loss, that was your own trouble. You could not hold the agent responsible. Now, around 13th centuries, the canon lawyers, if I say the canon lawyers, Roman law, there was what we call like the canon law, which grew out of the ecclesiastical law at the time. Don't forget, because of the history of the Christianity spreading to Rome, which was the center of the world at the time, and then from which it was spread to other parts of the world. Out of Roman law, also we developed what we call like the canon law, which was part of ecclesiastical law. And canon lawyers of the 13th century made significant contribution to what we will now be calling the concept of corporate personality and so on. So they developed the concept of corporation, and they develop it as a personal factor, that is, juristic or artificial person, to address the defect of absence of entity in commenda as a vehicle of business or investment. If you look at what you call the commenda, as we indicated, the business was not really seen as an entity in its own right. But then, when they developed this doctrine or this concept known as corporation, so the corporation in the legal mind became a stand-alone entity, what we call a juristic or artificial person, so that now we can begin to see something or transactional arrangement as being, if you like, an entity on its own, separate from the human beings who are in charge or who are using it. So that is very important point as we move on. Now, if you come down to England and Wales, as I indicated not long ago, the company has its origins in what we call the guilds, guilds, Association of the People of Similar Traits, and they were formed to pressure monopoly of particular traders and also to regulate members in carrying on their particular trade. So maybe those who deal in textiles or footwear or particular products, they will organize themselves into some kind of like an association so that they will discuss and champion matters which affect their common interests. So the purpose of the guild was to regulate and control a particular branch of trade rather than to create any form of corporate trading association. Now, as a result of growth in international trade, and as I have explained not long ago, that if you wanted to actually have what we called, corporation for purposes of running your business, you needed to get it from one of two ways. Either you got a charter, a royal charter that is from the king or the queen, depending upon who the monarch was, so that you are given that status, or Parliament will pass a legislation to set up a particular corporation, as it were. So most of the businesses which were taking part in export and imports at the time were actually given royal charter. And then the royal charter could also be given over particular region. So made that, for example, if you take the Hudson Bay Company, let's say they could be given a charter so that they are the only accredited, business to, for example, do particular type of business in certain region or part of the world. Or we take the East Indian Company, the same thing. Or the Baltic Trade Company, that is like the Baltic Seas. They have been recognized by the state, as it were. Now, it was this situation which existed, as I indicated, that because Royal Charter was given, certain businesses could actually, reach out to some individuals that had money to come and invest their money in it, just touting the fact that they enjoyed recognition of the monarch, like through the royal charter. So that was safe. But around the 17th century, we had a certain phenomenon. There's a particular company which was called like the South Sea Company. So the South Sea Company had been given a charter to actually trade in the South Sea, and they were actually taking a lot of, they were taking a lot of money from, people to try and invest. But the price of the shares which they were given were actually inflated. The business or the actual value of the company was not really the amount of money they were expecting people to be paying for the shares. So in no time, the company collapsed and people are actually disappointed. And that is what will set the stage for what we call the general legislation of incorporation, like getting a legislation which provides for how you can get incorporated company registered and run it without you having to actually go and get a royal charter or get parliament to pass a dedicated legislation for that purpose. That was it. So there was something we call the joint stock system, which actually evolved to try and address or mitigate the shortcomings or the flaws of the commenda. Don't forget the commenda, we said that it was neither a loan arrangement nor partnership arrangement. It was combination of both, where you give no money to someone to run a business. When he makes a profit, he come and give you some. If there's a loss, you cannot go and ask him. So that was certainly not right. And the business could collapse, and where the people who provided the money, for example, died, there will have to be reorganization of the business, like how partnership actually is, as we come to notice. So what was the joint stock company? In the joint stock, resources were pooled in a common enterprise. And a joint stock company created a permanent fund from shares in the stock of the company, invested by capitalists and managed by a select body drawn from members, what we will later on call board of directors. So unlike the commenda, where you just put money there, just give it to agent, and I will do whatever he wants with it. So the joint stock is like different people bring their money into a permanent fund. So they are the capitalists, if you like, or those who own the money. And they will select a body from those who have contributed the money. Just get a small group of people to come and manage the fund for it to generate more returns, and then it is shared among those who contributed it in proportion to their contribution. And then when members die, their shares could be sold to a new member. So unlike the commenda, where the death of the principal warranted reorganization, this was not like that. So this introduced a crucial element, what we call perpetuity. That is to say that the joint stock company, they could not die. The members could die, but the company live on. So later when we talk about consequences of incorporation, we talk about what we call perpetual succession. So this is where it started from. That the business has a perpetual succession, can continue to exist in perpetuity. And again, the concept of shares or stock had also developed. So the point we are trying to demonstrate is that the things that we take for granted in company law now, limited liability, shares, perpetual succession, separate legal personality, and so on and so forth. These are matters which did not emerge, in one neat form. They came up in bits and pieces. And eventually, they all come together and crystallize in organized law. That is what we have. So, for example, we have the case called the Salmon against the Hamborough Company Limited, a very old case, 17th century case. This is reported in 1671. And in that case, it's emphasized the ability to make calls on members to pay the company's debts. That is where the company has that members could be called upon to pay the debts. And I want you to pay attention here, and how we later on come and have what you call the limited liability. Because so far, the limited liability concept has not emerged, has not become part of the law. Perpetual succession has become part of the law, yes, but the limited liability is yet to come. So, in Salmon against the Hamburg Company Limited, we have one Dr. Salmon, and the House of Laws ordered the Chancellor to levy assessment on members of the joint stock company to pay for the liability sued for and the cost. So, in modern times, one will say that if there's a debt or any expenses to be made by the company, it's the company which will pay it, not the members, isn't it? But in the Salmon against Hamburg in the 17th century, members were actually ordered to pay for the debts of the company as it were. So in 1720, owing to growth of public markets, booms, and slumps, a legislation which we call the Bubbles Act was passed to regulate joint stock companies. So the act established the Royal Exchange and Landing Assurance Corporation. So what we definitely devote to currently call the London Stock Exchange, and forbade formation of any other joint stock companies unless approved by a royal charter to protect the South Sea Company. So there were restrictions that, yes, we did not want too many scandals. So this Bubbles Act is passed. We're going to regulate how joint stock companies even come into being and how they operate. And apart from a body which will develop to become like the London Stock Exchange, which you know as the Royal Exchange and London Assurance Corporation, it made it illegal for any other joint stock company to actually exist. And you needed a royal charter before you could do that. And all these things were done to protect what we call the South Sea Company. Now, there's a particular provision of the Bubble Act of 1720, which I have quoted. Quote, all undertakings presuming to act as a corporate body, raising transferable stock, transferring shares in such stock, either by act of parliament or any charter from the crown, enacting under any charter for raising a capital stock not intended by such charter, and all acting under any obsolete charter forever be deemed illegal and void. So this was a very sweeping legislation to try and check abuses in using, if you like, the corporate form, which was made possible by the joint stock arrangement and also by obtaining royal charter, as the case may be. But there were a lot of rumblings from the bench that joint stock companies were contrivances that were impermissible at common law. In other words, that joint stock company, it provided its own challenges, which defied basic, principles of common law. So it was eventually repealed in 1825. I'm talking about like the Bubble Act was eventually repealed in 1825. And in some cases, some judges had actually cast aspersions. For example, in Kinder against Taylor, Lord Eldon made a dicta or statement to the effect that acting as a corporation without being such is illegal at common law. We have prevented the formation of a number of companies. However, by the time the pressure to allow a wider array of corporations than those sanctioned by charter or act of parliament was becoming irresistible. So either you get a royal charter or you lobby members of parliament and then you get a particular legislation passed. for a particular company or corporation to be set up. So what was emerging was that some enterprises will exist and be recognized by those in commerce with or without legal sanction. So we had, if you like, a legal, quote and unquote, companies and then illegal companies, in the sense of they having been registered as through a royal charter or by a dedicated act of parliament. So the formal restrictions which had been imposed by the Bubble Act were no longer to be tolerated. And this was primarily because of the expensive nature of incorporation. How was it expensive? To get a royal charter, it was not a simple matter. Just let's have an analogy. How to get the charter as a university, right? Presbyterian University College had to go through a number of years before eventually, I think about 2-3 years ago or so, it was given a full charter. Now, in the same vein, if you needed a royal charter to have the juridical existence as a corporation in those days, it was not a straightforward matter. It was a bit expensive. So that was the challenge. In the same vein, if you wanted Parliament to pass a legislation to incorporate your business, that was a tall order as well. Legislation is very laborious and also expensive process. So therefore, only large enterprises were able to meet the price of incorporation, like to get a royal charter or to get the dedicated act of parliament. Now, all those developments will pave a way for the Joint Stock Companies Act of 1844. And how was it? So we had flagrant abuses of the existing system and a large number of frauds. For example, insurance industry led to the appointment in the early 1870s of the first comprehensive company law committee. And I have abbreviated or have abridged the history. Otherwise, we have talked about how the whole collapse of the South Sea Company even came about. And the literature or the commentators, they call it the bubble or bust. And why is it a bubble bust? Bubble bust in the sense that how the price of the shares were actually inflated and they were oversubscribed, but it did not last, and then in no time it collapsed. So that is why they have like that expression. But the abuses of the system led to setting up of a company and that of a committee, and that is what is of interest was a company law committee to look into what was the problem regarding businesses generally when it comes to incorporation and registration, and what had led to the various scandals and abuses. Recommendations of this Comprehensive Company Law Committee actually culminated in the adoption of what we called the Joint Stock Companies Act of 1844. And this was very important because that was the first general legislation, like general legislation in the sense that it provides like the blueprint. If you want the incorporated form, this is a procedure you must go through. So it's no longer necessary for you to go and get a royal charter or for you to get Parliament to pass a dedicated legislation before you can get the incorporated form to run your business as a company. So the Joint Stock Companies Act of 1844 gave birth to the first form of registered company. Registered company in the sense that a company not brought into existence pursuant to a royal charter or pursuant to a dedicated or legislation of parliament. So under the Act, that is the Joint Stock Companies Act, companies could be incorporated by registration if the company had more than 25 members. And pay attention to when we're giving the examples earlier on, we came across a provision in which we are told that one or more person, if you look at Section 6 of our Act 9929, one or more person may form an incorporated company under this Act. Now, when General Corporation Law was actually passed, the requirement was that you could be incorporated if the company had more than 25 members. So the Act also created the Office of Registrar of Companies at the time. So for the first time, the Office of Registrar of Companies was created. And it was going to serve as the place where particulars of registered companies will be lodged. And then the Act also further provided for registration of deed of settlement of companies. That is the principal constitutional documents. And in return for status, okay, if you want to be given the status of incorporated company, you need to do something. What do you have to do? You need to register the constitution which governs that company. So we later on talk about how to call the memorandum of association and an article of association. Then when is registered, then will give you a certificate to the effect that you have actually been incorporated. And you'll be recognized by law as an entity in your own right. Now, another point worth noting is that despite the creation of the registered company by the 1844 Act, that legislation did not confer on the membership of these companies limited liability. In other words, if you are a member of a company which had been registered under the 1844 Joint Stock Companies Act, you did not enjoy limited liability. That is to say that the debts and liabilities of the company could actually be extended to you. And liability was at that time seen as a means by which undercapitalized concerns might exploit the corporate body or entity to the detriment of creditors and investing public. In other words, no limited liability is the idea that where you have paid money to the company for the shares that have been issued to you, should the company run into debt and the company is insolvent or being liquidated, is closing down, is being dissolved, and there are no creditors chasing after the company, they cannot come after your money as a shareholder. All that you lose is the money that you paid for the shares. Or if you have not finished paying for the shares that were issued to you, then you'll be called upon to come and pay the unpaid value. But where you have fully paid for your shares, then even if what is left in the company is not enough to pay for the debts which are being claimed by various creditors, nobody can call upon you as a member or as a shareholder to come and pay more. So that is the idea of the limited liability. But initially, it wasn't really part of the law. So later on, the Limited Liability Act of 1855 was passed to supplement the 1844 Act, meaning that the Limited Liability Act of 1855 allowed companies with at least 25 members, each holding shares to the minimum value of £10, with at least 1/5 fully paid up on the share to incorporate with a limited liability status. So now more flesh is being added to the law. Initially, the first legislation only gave the incorporated status. There was nothing like limited liability. Now we have a legislation which has come to add the limited liability concept to the incorporated company, but there are conditions that the members will have to have at least shares of a certain minimum value, £10 at the time. And this £10, you must pay one fee fully. So 1/5 fully, so 1/5 of 10 will be probably 2. So £2, as it were, should be fully paid before you'll be accorded the limited liability status when it's incorporated. Now, prior to the Act, the ability to grant a limited liability status to small business had been subject of much discussion and severe reservations, which centered around the fear that general limited liability will result in undercapitalized concerns to the detriment of creditors and the general public interest. Let's unpack and understand this, because it's going to resonate in a modern company law. This is how things look like. A company is incorporated, and we say that it is limited liability, meaning that shareholders, after paying for the shares, nobody can call upon them to come and pay anything towards meeting any debt which the company may incur. Now, members of the general public, when they are dealing with the company, they are doing business with the company, they do that on understanding that the company has a certain capital, minimum capital, represented by the shares. But it's not all the time that they will be able to know the full capital position of the company in terms of like the share value. So they'll be doing business with the company, thinking that the company is financially strong, when in fact it may just be an empty shell. So they commit business and other things to the company. In no time, the company collapses and they are not able to get their money. Meanwhile, because of the limited liability concept, you can also not go after the shareholders that were actually behind the company, and creditors who have actually lost out. So that has been some of the concern which law reformers and commentators have been discussing. So if you look at the report of the Royal Commission on Mercantile Law and the Law of Partnership in 1854, for example, you get some of those sentiments which were articulated over there. Now, in accordance with the 1855 Act, a company was required to have not less than 3/4 of its nominal capital subscribed, and the word limited to its name. So more refinements were given that, okay, let the public know that you are a limited liability company, so the word limited should be at the end of your name. Now, if you look at our current regime, you notice that we've even gone a step further in terms of the names. We've gone a step further to indicate that. So later on, you can look at the section 21. if you go to section 21, we are told the last words of the name of private company limited by share is limited company, LTD. Then public company limited by share shall be public limited company, PLC, and so on and so forth. So it all has a history, and that is what we are going through. So liability was limited to the nominal value of the share. When we say nominal value of the share, that is the face value of the share, as it were. So eventually, the 1855 Act was incorporated into the Joint Stock Companies Act, and we had the one legislation which required an obligation on the part of a company to have a registered constitutional document, namely the Memorandum of Association and Articles of Association. And these replaced what used to be known as the Deed of Settlement. Initially, under the Joint Stock Companies Act, we needed to register Deed of Settlement, but this gave it what we call the Memorandum of Association and Articles of Association. And these are the constitutional documents of the company, but now we have actually moved away from it. And even in Ghana, we move away from this Memorandum of Association, Article of Association, as far back as 1963, when we had our first post-independence companies legislation. And we simply adopted regulation. And in 2019, we have also abandoned the language regulation, and we have moved to constitution. And we come and talk more about that later on. So to encourage smaller business enterprises to register as companies, the 1856 Act removed the restrictions relating to the minimum amount of capital to be contributed by members of the company, and also reduce the minimum number of members required for the purposes of incorporation from 25 to 7 members. So I asked you to read the case of Solomon and Solomon. And Solomon and Solomon, you not come across 25, you come across 7 members, because the law was subsequently amended to make it easier for people to be able to meet the requirements for incorporation. So unlike in the beginning, where you needed 25 members before you could register, now you needed only 7 members. So the various legislation, 1844, 1855, 1856, were all consolidated. That is, they were put together. Okay? They were consolidated into one piece of legislation known as the Companies Act of 1862. And the desire to encourage incorporation, that people wanting to get the incorporated company status, was fueled or promoted by acceleration in business activity due to the Industrial Revolution. So the Industrial Revolution also made the development of company law, very successful, because there were a lot of businesses and a lot of people wanted to take advantage of the new possibility which the law had brought into being. Now, we want to look at how the courts actually accepted the company as a separate legal entity. Well, the case which actually tested the efficacy of this legislative intervention with respect to incorporation was the case of Solomon and Solomon. However, before Solomon and Solomon, there had been some earlier examples of judicial acceptance of the ability to incorporate small businesses. So if you look at the literature, just for interest, you could see cases like Ray George, Newman and Co., and then Farrar and Farrar. they all touch on the legal reality that small enterprises could be incorporated. But we'll discuss the case of Solomon and Solomon later on when we are learning theory of incorporation and piercing the veil. But just whet your appetite, and those who have read it, you notice that there was a gentleman called Aaron, Solomon, and he had leather shoe business, which he had been running as a sole proprietor. So later on, when these developments had actually crystallized, and what was in vogue at the time was having incorporated company, he too decided to take advantage of the new mantra in town and whatever legal benefits that went with it. So he wanted to register his sole proprietorship business as a company. He did that with his good self, his wife, and then the 5 children. I think 5, yeah, with his children. And he was very smart. He decided to value his business, put money on it, and he made the business pay cash to him. Of course, as part of the payment, but that was supposed to be, it was put in the form like if you like a loan also in the business, what we call the venture later on. Now he created shares, and the shares are over 20,000 and then and 7 shares, a little over 20,000. And he practically had all the shares and had given only 1 shares each to his children and wife. In the course of time, he incurred trading difficulties and the business collapsed. So his creditors were chasing after their money with the business. And Mr. Salmon also was making a claim that he's also, in a sense, a creditor of the company because the company owes him, he being a debenture. That is part of the money that the company could not pay to him for his old business, which had been sunk into the company as a long-term loan, what you call like a debenture. And so he had to be paid before other unsecured trading creditors could also get theirs. And they felt that Mr. Solomon was trying to cheat them because you own the business, and the business that you are running in this community is the same business that you are doing. So how come that the company owes you? So the creditors wanted the court to disregard his claim. But then Mr. Solomon, of course, on his behalf by his lawyers, got the argument marshaled and deployed that upon incorporation, the company was a separate entity or separate person from him. The company was a legal person in its own right. And for that matter, it should not be seen as one and the same with the company. And if that is so, then he too could pursue his legitimate claim against the company as a debenture holder. So please, I have only just given what we call a preview of that case. But as I told you, I want you to read it in full, and we also discuss it in full when we are discussing the theory of incorporation and piercing the veil. Now let's come to Ghana. How they do get to where we are as far as our company law is concerned? Well, in our jurisdiction, Ghana, the first companies legislation directly applicable to companies was the Companies Ordinance 1907, which was a reproduction of the 1862 English Companies Act, which we'll be talking about. It was more or less like a copy and paste, as it were. But there was one major drawback about this 1907 legislation, which was subsequently amended in 1908. And what was that drawback? The drawback was that it was essentially cut and paste, and definitely reflected problems associated with legal transplant. When we say legal transplantation simply means that you take a law from a particular jurisdiction and you just impose it or you introduce it in another jurisdiction, just as it is. So just like transplant, you remove like a plant from one location and put it another. And certainly, law and legal institutions are influenced by so many factors, including the peculiar situation of the society in which that law was. So therefore, if you transplant law from one society and you want to impose it in another society without making any changes, you are going to run into rare problems. It's just like putting a round peg in a square hole and vice versa. So that was the situation with our first company's legislation. It was more or less copy and paste, a legal transplant. And it ignored both the legal development in England and also the different cultural, political, and economic situations in both coasts at the time. So therefore, when we had independence and the Republican status, not too long after that, our president at the time, Osajefo Dr. Kwame Nkrumah, commissioned the Venerable Professor L.C. Gawa to have regard to the realities of our political, economic, and social circumstances as an independent African state and look into the working and administration of the then company law. Find out what is not working, what needs to be changed. And if we look around African countries and other jurisdictions, are there best practices which we could actually draw upon? So Professor Gawa's commission was supposed to do all that and make recommendation for the amendments and alterations of the company's ordinance and such other relevant laws of Ghana. So the commission, what we call the Gawa's commission, was further charged with framing this recommendation to take into account the need for encouraging African enterprise in Ghana and encouragement of foreign investment therein. So this led to the promulgation of what we called the companies, it used to be called the Companies Code of 1963 at 179. It was just in 2004 that we changed the name from the Companies Code to the Companies Act, still 1963 at 179, as a result of the Statute Law Revision Commission Act, which was done by Justice V.C.R.A.C. Crabb. But then, as we know, this legislation has subsequently been repealed by the Companies Act of 2019 at 992. So I would like you to read at 179 and at 992 and identify some of the legal differences and similarities. Maybe to help you to do that. And when I say these things, if you try to attempt your hands on them, I think it will deepen your appreciation of the law. Okay? It's not mandatory, but if you take it, it will. So if you look at the legislation, please, those who have the printed version or anything, go to page 16. Page 16, 17, right up to page 23. You see what they call comparative table. So there are two columns. Companies Act 1963 at 179, one column, and then Companies Bill 2018 in there's another column. So you see, let's say that Section 1 of the Companies Act 179 is now reenacted as Section 387. So that is to tell you that bulk of the provisions of Act 179 now were actually retained and reenacted in Act 992. But of course, there have been some changes as well. So now I would like to explore the trajectories. That is the paths which the new Companies Act had actually followed based upon all that our company law has been since the 1963. So as we have noted, the Companies Act 2019 Act 992 repealed and replaced the Companies Act 1963 at 179. And this Act 992 has introduced some novel provisions. When I say novel provision, that is new provisions, which is in essence a whole departure from the provisions of Act 179. We'd like to highlight few. You can look for more. So first, Act 992 abolishes the need to file a constitution as part of the incorporation process, as one of your friends rightly pointed out. Previously, it was mandatory for you to accompany your application for registration with proposed regulation, which used to be like the name of the constitution at the time. But now, it's not mandatory. There is a default constitution in the Companies Act 2019, which you can use if you decide not to register your own constitution. Another point is that Act 992 changes the use of regulation to constitution. So regulation is not used. We use the word constitution. And then Act 992 abolishes ultra vires doctrine, as it were. Or even if it does not abolish it, it substantially makes it redundant, unlike what the situation used to be in Act 179. Also, Act 992 provides surfaces to companies' names. So I just mentioned Section 21, for example, which has provided that if you're a private company limited by shares, then your name will have ending limited company or abbreviation LTD. Also, if you are public or limited by shares, your ending will be public limited company or PLC. If you're a company limited by guarantee, it shall be limited by guarantee LBG. If it's a private company limited by shares, it shall be PRUC. If it's a public company limited by shares, it shall be PUC. Now, previously, we did not have this distinction, and all that we had was if it was company limited by shares, they will have a limited. and there was no distinction as to whether it was a private company limited by shares or public company limited by shares. But now Act 992 has come to, sort of clarified by insisting that we need to have differentiated abbreviations to end them. So let's keep that in mind. Also, under Act 992, major transactions require authorization of shareholders. There's also creation of Office of Registrar of Companies. Electronic or digital means of registration, communication and service is also allowed. So now, previously, everything will have to be by hard copy posting. It is now possible to even send reports by emails and so on. Well, we also talk about the financial statement in place of account, but it's minor though by just the semantics, but the substance is the same. Now, derivative actions have also been provided explicitly. That is where members of the company can use the name of the company to sue, instead of like the company itself, especially if the directors would not act. In the same vein, there are the retention of the prospective provisions pending their inclusion in a separate Security Industries Act. So if you look at the Act 179, there are provisions which relates to what we called invitation to the public. When you make invitation to the public to come and subscribe for shares or security of the company, the whole rules which govern that. For example, the prospectus information you are trying to use to entice the public to believe in the company. Those provisions were carried over from Act 179 until there have been re-enactment in a new legislation for that purpose. If you're interested in knowing more about these modifications by Act 992, I encourage you to read Professor Dateba's article, Revitalizing Gawa's Legacy, Reforming Company Law in Ghana, which was published 2011. Okay, so this will mark the end of the introduction before we move on to our next topic. So if we take some 3 minutes break and then we start another topic.